Good afternoon, Mr. Faulkner.
Good afternoon, Judge. How are you?
I'm well. Yourself?
Good, thank you.
Any sense of whether Mr. Smith is joining us?
He is going to join us. We've had some email exchange about 15 minutes ago.
This isn't a just in the nick of time, he's getting you everything email.
No, it is not. It is a plead mercy email where he has an idea, and
Okay. Well, I, of course, will give him a chance to express himself, and I will hear from you, and we will proceed accordingly with a case from 2019. I will sit tight, and we'll give Mr. Smith a couple minutes to connect, and otherwise we will go forward.
Okay, thank you.
Sure. All right, we're going to get started. It is 6 minutes after 1. We were set to start at 1, and Mr. Faulkner, sounds like you have confirmation that Mr. Smith knows we're meeting today, and some might say this is emblematic of why we're having to have this discussion. Because, no Mr. Smith and no updates from his client. We're here because you, on behalf of your clients, have filed not a first, but a second motion for sanctions. We had, I thought, a productive conversation back in November of last year that resulted in, I guess it was October. It took me a little while to get the order out. But it resulted in an order in mid-November making very clear, I felt, to defendant Stevens and his lawyer what needed to happen belatedly in connection with discovery requests that you had propounded. It's my understanding that none of those discovery requests have been satisfied or have some, and I guess I should be specific. One bullet point was you need to respond to these discovery requests. A second was your client needs to sit for a deposition. Any of that happen?
Yeah, it happened. Now some of it happened
Okay.
in a delayed timeline, Your Honor. So the first part of the first bullet of the order was, sorry, Your Honor, Adam is sending me an email right now. He says he can't find the Zoom link. They're on his calendar, but not on this one. And he wants me to forward it to him. So if you want, Your Honor, I can.
If you don't, Ms. Niles, it's better to hear from him than not.
Yep.
But if you don't mind sending it, I appreciate you sort of holding his hand through this process.
Sure, I'm going to send it to him right now. Okay. Okay. I just emailed him.
Keep talking. He will patch in when he patches in. So you did get some things, but not by the deadline set in the November 13th order.
That's where I was, Your Honor, right? So he had until the 20th to answer the discovery request, the interrogatories. They were not answered until the 28th of December after much requests and back and forth, and they were coming, and I got them. When I received them, they're not verified. They're not signed by anybody. I assume when I read them, they were not signed, they were not drafted by the defendant, but rather his son. So we had follow-up conversations about when am I going to get the deposition of Mr. Stevens, and there was a lot of difficulty back and forth, and some of that, according to Adam, was that Mr. Stevens, it's hard to get to him. It's, he's elderly, and et cetera, et cetera.
So
that
Mr.
went on for a while.
And son, I'm sorry to interrupt, but Mr. Stevens's son is what relation to your client?
He is not a party to this case at all. He is no relation to my clients. My clients don't even know him or his.
Well, I'm confused. I thought your clients are related to Mr. Stevens.
Through a marriage with their mother. Their mother was married to Mr. Stevens.
Okay.
They represent her estate.
So why then Mr. Stevens's son would be a stepbrother of some sort?
Yeah, kind of, right.
Okay.
Yeah.
Not a blood relative, but at least by way of marriage, they were step siblings.
Yep, that's right.
Okay.
So he was supposed to sit by the end of the year for his deposition. We received the discovery on the 28th. I asked immediately by the 30th, when am I going to get his deposition? By that time, when I had already filed the second motion for sanctions. So we filed that on the 14th, then received the responses, the unverified, on the 28th. Never got a date for a deposition. I asked for the son because apparently he had been given Adam the information for the interrogatories. That's the way the interrogatories read, like they came from somebody else. And so I said, fine, give me the son instead. We'll start with him and go from there. Maybe he can answer the questions, maybe he can't. And so after that, I told Adam, I have to proceed with this motion. We're getting nowhere. I have to leave it. After that, Adam confided via email, the son has not responded to any of Adam's requests for follow-up, whether that be in a phone call or emails. He simply is not responsive at all. And I do not know if Adam has had conversations with other children of Mr. Stevens. I believe he has a daughter. I don't know where she lives or if she lives in Tennessee with him. All that I know is the son is MIA. Mr. Stevens is unwilling to sit for a deposition to answer questions, even when I proposed to do it in an outdoor setting before the winter or in some other facility that would allow him to feel safe. Even if a videographer was there and I was still here, so that is not to crowd his house. I told him I'd do whatever I needed to do to get it done.
Sure.
And I don't believe Adam is the cause of this at all. I'm not going to throw shade on Adam. He and I have had he's been very candid with me. I believe it's his client that is not cooperative.
It sounds like there maybe is something going on the Stevens side of things that isn't aligning well with us getting work done on this case.
Yeah. It seems to be not moving at all, despite the requests. I think I've been, I was pretty darn lenient. We were supposed to have things done by the 20th. I waited at least another almost 30 days before filing the second motion.
I don't feel like you're being pushy here. I think you've been patient and accommodating. And my sense of Mr. Smith, the one time I interacted with him, was that he seemed like a good guy too. Maybe his client was a little difficult, and you are confirming that to a certain extent. Although Mr. Smith not plugging into this call suggests that there may be a collection of issues on the defense side, none of which need to be your client's problem.
Right. And Adam sent me, while he's not here, I'll tell you what he proposed. He asked me to table this for about 3 weeks so he could drive to Tennessee and yell at Mr. Stevens through the door if need be. And I said, I cannot accommodate that. It's too late for me to agree to that.
That time's passed. It's probably colder now than it was in December. December would have been the time to do that.
Yeah.
Now he may need a snowmobile to accomplish that, but sort of 2.5 or a month and a half late on that front. What's the relief you're seeking in your motion? You talk about, and I appreciate your candor in it, that it can't just be that I issue certain sanctions. There has to be a hearing, which we're having right now. It's a little one-sided, but it's not your fault. But what is the sanction that you're seeking?
Your Honor, we're asking for, the rule allows you to be very harsh in your sanctions.
Hold on 1 second. Mr. Smith has just landed in the waiting room.
Okay, finally got it.
Hello, Mr. Smith.
Hey, Judge, apologize for that. I've never had one of these, like where the link was installed in the PDF and it didn't want to open and I had to re-download Zoom.
Okay, but you're with us now.
I'm here now.
So I started the hearing, and I'll tell you what I've heard so far. I'll give you a chance to catch up. Mr. Faulkner shared with me that you, and when I say you, I am not attributing any of this to you personally or professionally. It's you. In fact, what I'm going to say is Mr. Stevens, because that's ultimately the person who's being sued here. Mr. Stevens did not comply with any of the deadlines that were set in the order that I entered as a result of our last Zoom session. We had a Zoom session on October 23rd, and a few weeks after that, I entered an order. I was a little late in getting the order in, but it reflected deadlines that we had agreed to at the hearing we had. All those deadlines were missed. Arguably, they both remain unsatisfied. Mr. Faulkner explained that repeated efforts on his part and many efforts on your part yielded unverified interrogatory answers, probably from your client's son rather than your client. It's something, probably not enough, and still no deposition of your client, and now not even a deposition of his son. And Mr. Faulkner shared with me his sense that this was not because you weren't trying to get it to happen, but that you were running into, hopefully for you, unprecedented lack of cooperation from a client or a client's family. So here we are, and Mr. Faulkner was just about to tell me what relief he is seeking. And he did also, I believe, has been real candid about the exchanges you've been having. He shared with me, and you'll get a chance to add, that you are pleading with him so that he might not object to you pleading with me to have yet another chance. And what you were proposing was braving the chill temperatures and wilds of wherever it is in Tennessee Mr. Stevens lives, to bang on his door and say, hey, it's me, your lawyer. You need to engage on this or else. And that was how you had left things with Mr. Faulkner, and now we're here. So I want to give you a chance to flesh out the story if you think there is more to it than what Mr. Faulkner shared with me. And after you've done that, I want to give Mr. Faulkner an opportunity to say, I hear all that, but here's what I think you ought to do, Judge. And then I'll give you, Mr. Smith, the same chance to say, please don't do that. Let's do this. And I'll be in a position to decide what to do. Okay.
I really do appreciate his candor in delivering that. Everything he said is absolutely true. The only thing I would add is that my client is 95, 96 years old. I'm sure they're scared to death of this corona stuff. I mean, they've mentioned several times how it's impeded their life, and that's just coming from the son, because Mr. Stevens himself is not one who can use technology. He's not one who can hear well enough to talk to on the phone. I have met with him in person before, but I did have to go to Tennessee in order to do that. And now, as of getting those last sets of interrogatories that were not verified back, when I reached out to him and tried to squeeze them to get it verified, they just simply have stopped communicating with me whatsoever. And that's the situation. I sent them a letter about 2 weeks ago. I think I told Mr. Faulkner when I sent that. And so now my only real option, I feel like, is to go there, knock on the door, and be like, hey, are y'all getting what I'm saying? Do you still want me to be your attorney? Do you realize how serious this is? Because I feel like it's one of those things that it's going to end up, they'll point the finger at me, once they end up in a hole.
How did you come to be counsel for Mr. Stevens? If he's in Tennessee and you're down here, not that you're not famous or anything like that. That's not my point.
No,
I'm just
not.
curious how you ended up holding this one.
My mentor, who was originally on the case that the state bar assigned me, Charles Davis, they came to him because apparently they used to live in Fairburn, Georgia, and that's where his office is, and that's where he's always been. And he didn't really want to fool with the case, frankly. And so he just kind of looped me in on it. And, which I more than enjoyed working with him on it, and think I learned a lot throughout the process. But he eventually got out of the case. So that's how I ended up with it.
Got it. So the moral of the story for you is don't take any more hand-me-downs from your mentor. There's a reason why he's giving you the case, and it's not so you can make $1 million.
Yeah.
Okay. All right. So I appreciate you sharing that and reminding me that Mr. Stevens is not a 32-year-old technologically savvy individual, but that he faces some obstacles, and that I'm remembering that now. So those were things you had shared before. Anything else you want to add before I hear from Mr. Faulkner about next steps?
I would say, like, his only contact with the outside world is through his son and his daughter. His son lives with him, it's my understanding, and his daughter's over there regularly, but they are borderline just as bad. I mean, they're in their like mid 50-ish age, I would guess, but they're like still using flip phones. They probably can work a TV pretty well, but that's about it. So trying to explain to them how to do this, I would imagine would be pretty difficult. I've kind of tried to go ahead and just layman's term, give them, hey, they're wanting to, over a video screen, talk to you and ask you some questions. But as far as explaining to them how to download Zoom and get a webcam and that sort of thing could be difficult. And as far as those unverified interrogatories, I got to thinking about it, there's no way they're figuring out the remote notary thing. I don't know how they would get them notarized without exposing Mr. Stevens to a stranger. And I would think the way that they are, from where I've talked to them, they're the type that they're probably scared to go to Walmart.
So you mentioned one other potential player in the mix, and that is a daughter of Mr. Stevens. Is that someone with whom you have contact, or you have worked through the son?
Just the son. She kind of will give her input but she, I don't think is as educated as the son and has been out as much in the world. And I don't think she really realizes what's going on here.
Okay.
So she's just kind of a caretaker.
Got it. And the son, you believe, you're not swearing by this, but you believe that he resides with Mr. Stevens.
I do believe he does.
Okay. All right. Thank you. So, Mr. Faulkner, you were on the verge of telling me what you thought I ought to do as a result of where we are, late February, and you still not having certain things. And Mr. Smith was able to join us. So let's pick up where we left off with you.
Thank you, Your Honor. 91137 gives you broad discretion in sanctioning a party for willful violation of discovery rules and discovery orders. And the review of the facts here, it's clear that they were aware of the discovery in the beginning. Mr. Stevens and his agent, his son, clearly received the interrogatories and the request for production, clearly knew of the dates that you issued when they were not originally answered. Adam has communicated that they were aware. Then we finally got the responses from them, despite the plea that they are unsophisticated or remote. I find it hard to believe that they don't understand what a court order is, and the severity of not complying with a court order. And so to me, the facts show Adam has done a lot of effort to try to get these responses. He has repeatedly communicated to me that he has been making these efforts, and they are not complying with him. Refusal to return a phone call, refusal to return an email is willful. When there is no evidence to show that they didn't receive those, that they didn't have any idea what their obligations were. They knew, plain and clear. And you don't have to be sophisticated to know what a court order is. You just know that it's a court order, and it's your job to respond to it. So I view them as being willfully disregarding the court order, willfully disregarding my repeated requests under the rules to have discovery, to understand what his defense is, and to be prepared for a trial. And because it's willful, the rule gives you broad discretion, Your Honor, about what sanctions to levy. And the sanctions that my clients are requesting for violating the discovery order and the rules is to have a default judgment entered by striking his pleadings. Just striking his defenses, Mr. Stevens' defenses to the claims, allows the court to then enter a default judgment, and we will have a hearing on damages instead of having the full-blown hearing, because he's had his opportunity for a defense. He's decided to ignore his opportunity and to ignore us. And I think that's willful, and the rules allow you to take this sanction, even though it's severe. And I've cited several cases in the motion that I filed for support for this sanction. So, Your Honor, we're going to ask that you issue an order striking his defenses and the default be entered against Mr. Stevens.
Mr. Faulkner, there is a line in your motion for sanctions that reads, it's the last sentence in paragraph 6. It says, defendant has thumbed his nose at plaintiffs from proceeding prior to this matter, during this matter, and now even after the court's previous sanction. I get the second two, but what are you referring to when you say prior to this matter?
So prior to filing suit, we've made several attempts to, it goes back further than that. There was a probate case in Fulton County when Miss Stevens was alive. Mr. Stevens was initially her guardian, appointed. And it's in our petition to some extent, didn't take care of his wife. He was eventually removed upon the recommendation of the Department of Family Services, having investigated the matter, and his daughters were appointed. He refused a court order at that time to turn over the bank accounts that belonged to Mrs. Stevens.
Okay, that gets us into this litigation from there.
Yep.
I'm remembering some of this now. Okay. Mr. Smith, were you involved in representing any of Mr. Stevens's interests prior to this lawsuit, or you came in because your mentor brought you in because your mentor was asked to represent Mr. Stevens in this lawsuit?
Yes, Judge, I definitely did not have anything to do with them at that time. And it's my understanding Charles did not know them either. They kind of popped in his office after Mr. Faulkner filed his first couple of complaints.
Okay, got it.
And if I could just add one thing to what he has said.
It's your turn. You let me know what you think ought to happen here at the end of February 2021 in this 2019 lawsuit.
I believe it's definitely true that there has been some willful disregard by Andy's son, but Gene's not the client here, nor is he the defendant. And I think Mr. Stevens, the only way he's able to act is what he gets from Gene yelling at him in his ear. I mean, like I said, he's a 90-something-year-old man, and that's the reason that I say I feel like I should go speak directly to him because, yeah, Gene has stopped communicating with me, and Gene is definitely not doing what I asked him to do, and it's not responding to emails or letters, or accepting certified letters for that matter. But Mr. Andy Stevens, I don't know of him doing anything wrong. When I met with him, he had a different set of facts that he wanted to explain. He felt like he had taken ample care of his wife. Whether he did or not, I don't know. I wasn't there. And I could even understand the situation where an older person trying to care for another older person, like you think you're doing a good job, but really it's a mess. And so he has those positions. I don't think he has been a willful bad actor at any point along the way.
So let me ask you, Mr. Faulkner, about Mr. Smith raises an interesting point. He said, look, Gene's been a pain in the rear. My words, not his. Gene's the son, as I understand it. But Andy, the Mr. Stevens you've sued, he may well be happy to help. Gene is sort of in the way, making this more difficult. In some ways, that's not your client's problem, but the actor here, the parties here, Gene's not a party. In fact, you used those words before Mr. Smith joined us on the call. The guy's not a party. When you were explaining and responses to interrogatories from the son, is that even responsive? He's not a party. But if he is the obstacle that Mr. Smith is running into, how does that affect an analysis that I need to conduct about whether defendant Smith is willfully disregarding the directions from the court?
Good question, Your Honor. I guess the first question I have, in respect, not to Your Honor, but maybe to Adam, is does Gene operate under a power of attorney? Is he a designated agent of the defendant? And if he is, his actions.
Well, that makes it easy. If he, and I don't know, and I was going to ask Mr. Smith that. It doesn't sound like that is a group that is necessarily following those formal procedures.
Yeah, maybe not, right? But the other side of that is a confidential relationship can lead to an agency.
Yeah.
If the son is living with the decedent, taking care of him, obviously he's taking care of his business. If he's dealing with this lawsuit, a confidential relationship can impute an agency relationship. And so in that regard, the principal can be liable for the agent's actions when everybody else in the world relies upon the agent as speaking for the principal. And so in my mind, Gene may be steering the boat, so to speak, but it's Andy's fuel that's paying for the gas, right? Or Andy's money paying for the gas in the boat. And so I think, and I hold this position only because I know the probate case file, and back then Mr. Stevens was uncooperative in the probate court and derelict in responding to those issues. And
so you're seeing more of the same.
I am.
And what because you were plugged in earlier and you've dived deeper into the probate matter than Mr. Smith has had need to, you are seeing an extension of conduct that started with Gene not being a part of it at all. Gene was not the source of delay or obstruction or cantankerousness on the probate side. That was Andy, all by himself.
That's right, Your Honor. And so I don't, even if it is Gene that's in the way, the apple doesn't fall far from the tree from my experience.
Okay.
And I would suggest that from the facts that Gene's just the agent of Andy. And therefore Andy's just as liable as Gene is for obstructing this.
Okay. Mr. Smith, anything else you want to add? I will acknowledge this is a complicated one, and you in particular are in a tough spot because you are doing what you can, short of some sort of Herculean efforts like getting on a snowmobile to get to your client's house and hoping they don't shoot you. Anything you want to add?
I would just add that I think there's definitely no power of attorney I'm aware of, but I think there is for sure an agency relationship there to some extent. But that being said, I don't think it fully covers everything to do with this lawsuit. Otherwise, like when we went to his house, we would have just met with Gene, or we would have just talked with Gene over the phone. Mr. Stevens is still calling the important shots, like whether or not to obey a court order, I would think would be a call he would make directly, just given the way it went. And his mind is pretty sharp. It's just his ability to hear and understand what you're saying. He even remembered a bank account number, spit it out off the top of his head that's like 15 years old. Charles like fell on the floor when he did that. So, I think he's a credible witness. And I just think it would be unfair to him to completely miss his chance to say his part about what he feels he did to care for his wife.
Okay.
But at the same time, I do understand that he's an old man and he could die, and it would put Mr. Faulkner in a very tough situation.
I think everyone's in a bit of a pickle here, and I just need to work through how much of that pickle is caused by things that your client has done or has declined to do. So this has been a helpful conversation. Mr. Faulkner, anything you want to add?
No, I think I've said it already, Your Honor. I just think it's too late to give another opportunity.
Okay. Mr. Smith, anything else?
No, Judge, I would just ask the court try and just think of Mr. Andy Stevens here when doing this evaluation and kind of leave Gene out of it.
Got it. Will do. We'll appreciate you dialing in, gentlemen. Stay safe out there, and I will get an order out soon that addresses the issues that we talked about today.